I welcome this opportunity to engage with what I understand today is representatives from the design space. I'm just really glad that Creative Dignity has been able to create a platform of this nature where there's learning and collaboration, because I do believe that there is, like Anchal said in her introduction at the beginning, I come from a place where I have seen in a lot of conversations around craft, etc., that there's a lot of misconception, and consequently, people operate from a place of either myths or lack of knowledge about what is protectable, what they can do and can't do, and that ends up becoming a bit of a sort of disincentive to actually either look at how they can protect their own works because everyone thinks, oh, nothing happens, or even look at how they can enforce their works. So, on that note, I will say that I'm going to split up today's conversation into two. One is guide you through the process of protection and look at, depending on what your output is, look at the various kinds of ways in which you can protect that output. And then I'm going to take you through a conversation around what you can do to enforce your rights. I mean, we have, for example, Meeta in the room, who is someone who is extremely loath to go after people who copy her work. And it took a fair bit of convincing, and then Meeta saw the results of that. So many of us here in this room have had the experience of, trying to enforce our works and realizing, hey, our laws are not so bad after all as we, were led to believe. So that's a good way to sort of segue to the next segment about enforcement. But first things first, let's begin with a conversation around what you can protect. When we talk about protection, at least as far as design folks are concerned, of course, there are many, many different forms of intellectual property rights. But for design folks, um, I'm really looking at the two broad buckets of rights, which are design rights and copyrights. Now, we are on the cusp of a situation where, and I don't know how many people it applies to in the room, but we often have funding coming in. We have designers who are getting third-party funding, who are getting, a lot of corporate interest and so on. And I do want to say that sometimes protecting your designs is not only about, doing it for your own sake, but doing it in order to be able to increase the valuation of the work you do from a commercial point of view. Because you have to understand that even your long-term profits, your ability to license something, your ability to claim royalty, valuation, all of that stems from your willingness to protect your design. So it's also important if one looks at it through the lens of the commerce that you are engaged in and not just the art. So it's very important to think of that. Historically, if you think about copyright law, the broad distinction between our copyright law and our design law is that copyright law was created to protect authors and artists, and design law was created to protect commercial products. You will see an overlap. I will explain the overlaps to you, but you have to understand that at the end of the day, the law is geared such that copyright law protects artists and design law protects commercial products. Why do I say the law is geared in that fashion? The distinction between the two is apparent. If you don't register a design, you have no rights. So because it's intended to protect commercial products, the understanding is that you will apply for registration, you will register a design, you'll go through those process steps. Copyright, on the other hand, is something that you have a right over even if you don't register it. So because it's intended to protect authors and artists, the idea was that there shouldn't be too much of a burden on you as authors and artists, and therefore copyright law was geared such that registration is not a mandatory requirement in order to be able to claim copyright over something. Copyright protects purely artistic works. Now, what does purely artistic work mean? At the end of the day, we all know that a perception as to what is art is really, it differs from individual to individual. It's very personal. So it's not as if some government employee in the intellectual property office is sitting and making a decision as to whether your work satisfies the threshold of art as he or she understands it. No, not really. When you say it's a purely artistic work, what you're really saying is that it is something that is a creation that you have come up with. In other words, it's not simply a combination of colors. It could be, could it be lines and dots, taking it a step beyond just colors? Sure, it could be lines and dots, but if those lines and dots form a pattern in a particular format, there's a particular sequence in which those lines and dots appear, then even lines and dots could be part of a pattern. The point is it artistic? Does it have artistic merit? And is that artistic merit something that emanates from you as the creator? That is the test of whether you own the copyright over something or not. Within that, there are slight granular differences that you must understand. If you are an employee of an organization, say, for example, you are, the creative director or somebody who's working with, say, a Swadesh or a Tanera or an Antaran, and, you're the in-house designer. So you will have to look very carefully at the contract you have with them, because the legal position, the default position is that if you are employed by somebody in your capacity as a designer, then the work that you create, the copyright is something that is owned by your employer. But people may have contracts which say that, look, there is an X amount of stuff that you're going to be creating for us. Anything you create outside the scope of that X is yours and you can own the copyright over it. So sometimes when you're negotiating contracts, it's very, very important to ensure that you negotiate a contract so that anything that you're making, which is outside the scope of your employment, as it were, remains with you and doesn't go away to the company. We see a lot of instances in the academic space where professors don't realize that, inventions they come up with or stuff they come up with in the lab actually belongs to the university because of the contracts they signed with the university. So very important to look at some of those contracts that you sign. So if you are not employed by anybody, then obviously anything that where you employ your skill and labor. Interestingly, there is an old case in copyright law called Feist versus Rural Telephone. And the law it lays down is something that is not going to appeal to y'all as designers, because it says it's a sweat of the brow test, that anything where you have expended sweat from your brow is really your work. So that expending sweat from your brow need not only mean something that has great artistic merit, it could even be something like, so for example, in that particular case, it was a telephone directory. And the question was, the names and addresses don't belong to anyone. So can you claim copyright over a directory where those names and addresses are arranged in alphabetical order by somebody? And the answer is yes, because that process of compilation also involves sweat of the brow. So this is why, the reason why I'm saying this is a context to it. Why am I, talking about all this stuff to designers? Because a lot of times people get into that whole quandary of saying, hey, in the work that I'm producing, I am using traditional motifs. So that possibly means that I have no ownership over it. That's not true. You may take a traditional motif, something as basic as an ambi, and you interpret it differently, or you arrange it in a particular form. I see as Mita's background, cacti, right? Or a tree, but that's her own unique spin to it. When you give your own unique spin to it and you create something out of it, even if it's a traditional, so it's not as if the motif you come up with has to be unrecognizable. It's something that has to be like an abstract made up motif. It could be something which is a perfectly traditional motif that you've taken and interpreted in your own way, or you've taken and sort of the number of times the motif appears in a particular sequence, or what motif. So, for example, if you look at something like, say, a Kanjivaram sari, a traditional Kanjivaram sari, it may have a bunch of really familiar traditional buttas. But the size of the buttas, the way those buttas repeat, the way the border is arranged, the color combination of the sari, what the pallu looks like, what other buttas are put in conjunction with it, all of that, when seen together as an aggregate, results in the sari being a copyrightable work. So it's very important to understand that you don't have to necessarily be the creator of that particular, for each motif. You could be the owner of copyright also by virtue of having put it all together in a particular format. Designs are essentially, so the distinction is, like I said, in copyrights, they have to be purely artistic works. As far as designs are concerned, they have to have eye appeal and capable of industrial application. What does that mean? It means if there is a functional aspect to what you're making, then that functionality is something that is not protectable as a design, right? It has to have an eye appeal and it has to be, so I'll come to the industrial application bit in a bit. So let's take a chair. The fact that a chair has 4 legs is the functionality of the chair. So you cannot protect a basic chair with 4 legs under the Designs Act. But you're a wood carver or you engage a wood carver and you make these really complex, filigreed legs of the chair, whatever, carved legs with a particular design on them. Then that chair with those interesting legs can be protectable under the Designs Act. So what you're registering is not a chair with 4 legs, but you are registering a chair that has a particular eye appeal, right? Because of the artistic work you have imparted to those 4 legs. Fair? That's clear to understand? So now what we're coming to is, like I said, originality is the test. Who created something is the test, right? If you are merely a job worker, you're executing the instructions of someone else. That person is telling you, say, a block printer, right? The designer is saying, this is the block that I have got carved from the wood carver. This is what the block looks like. This is the die that I have got made, or I'm instructing someone to make in this particular composition. You, XYZ, take this block, dip it in this die, and put it on this sheet of cloth in, gaps of 1 inch or whatever, and you put it in a straight line. So there is obviously a lot of effort involved in executing that. But does that person own the copyright because you're putting those blocks on that cloth? The answer is no. The creator of the design, which is then executed on the wooden block, namely the original designer, is the owner of the copyright in that. So sweat of the brow can't be looked at in isolation to say that, look, as long as, so then what happens is the person who is carrying a load on his back of saris, we'll deal with legal questions. We'll come to that in a bit. Esoteric, yeah, what is original? Of course, none of us have an answer to that. But I'm pretty sure that at least in the context that I am talking about, you know what I'm talking about, right? When I'm talking about originality, when I'm talking about something you've created, I'm sure you know what I'm talking about. So is sweat of the brow to be of the labor who carries the cloth on his back and delivers it from place A to place B? No, obviously there's sweat of the brow involved, but that's not what we're talking about. We're talking about creators and artistic works that are created by those creators. I will come to some examples in a bit. So going back now, doing this transition from copyright to design, why that transition is important is because there is an overlap in the legal provision. Now, when you look at the Designs Act, what the Designs Act essentially says is, like I said, functionality is not protectable. So if something is purely functional by its very nature, so I'll give you an example. You take a toothbrush, right? A toothbrush has bristles. Bristles are functional, but you take bristles and you give them like a funky shape. Some bristles are pointy, some bristles point outwards, some are outwards, some are inwards. So something as basic and mundane as bristles, right? If you take something even like that, then also you can claim design protection on the basis of the fact that it's not only functional. The test is it only functional? Is there no other way of performing that function than to do it in that particular shape? So if you say there is no way to ensure equilibrium and make sure that the chair is standing without 4 legs. So the existence of the 4 legs is functional, but the design on the 4 legs is protectable. Do you understand the distinction between the two? Now, if you're moving on to industrial application, like I said, the Designs Act was intended to protect creations that are capable of industrial application. What does that mean? Industrial application doesn't only mean that it's made in a factory. Industrial application means that it could be part manual and part mechanical. The idea is it's reproducible. Say you're a painter. You paint something on a sheet of paper. Even if you try to recreate that same painting again, The moment you take another sheet of paper and try to recreate it, it will not look identical because it's something you've painted at that point in time. So it is not replicable. A painter's painting is not replicable to that extent. So the Designs Act protects something that is replicable. Whether that replicable is a manual process, blocks, weaving, etc., or it is a purely mechanical process, making of upholstery or whatever, anything that's done by the machine. Anything that can be made in multiple copies and is replicable is protected under the Designs Act. Now, there is an overlap clearly because, like I said, something that is an artistic work could be a garment. Something that is an artistic work, if it's a garment and is replicable, could also be registered under the Designs Act. So how do you resolve this contradiction of whether to seek copyright protection or to seek design protection? Design protection, first of all, extends for 15 years. Copyright protection is 60 years after the life of the author or the creator. Or in the case of published works like books and films, etc., it's 60 years after the date of publication of the work. So obviously, copyright protection is a lot longer. The problem, however, like I said, is that copyright protection is something that you get without registration. So there isn't a lot of scrutiny that goes into copyright protection. So a lot of times people turn around and say, hey, it's not similar, or you didn't come up with it first, and they'll challenge your title. So for an unregistered right, it's always a bit of course, you can register your copyright as well, but it doesn't have the same level of scrutiny. So that's always a bit of a challenge when you're trying to assert a copyright because people push back a lot, right? And then they challenge it. So if you have a design registration, it's a little bit easier, especially if you're going to court. It's a little bit easier because it's a registered right. So that registration certificate forms, a document that a court is willing to consider a little bit more, right? So that way, it's sort of a little bit helpful. But as far as the overlap is concerned, what the law says is that if you are claiming copyright over an article, so remember the distinction between copyright over what we call the underlying work, namely the sketch or the painting, versus the article, which is the garment on which that sketch or the painting has been reproduced. Those are the underlying work, which is typically the 2D work, and the garment or the finished article, which is typically 3D. That's the distinction, right? So if it is possible to secure design protection for the finished work, and you have chosen not to seek design registration for that finished work, then what ends up happening is you can claim copyright. So like I said, design rights, if you don't have a registered right, you can't claim it, right? So you can claim copyright over that article up until such time that that article has been reproduced by an industrial process 50 times. In other words, you can claim unregistered copyright over an article that is capable of design protection, but only up to the 49th copy. Because the 50 is an arbitrary number that has been put into our law. Basically, what they're saying is anything below 50 is like small scale, again, protecting artists and authors. Anything beyond 50 seems to be a large commercial production. So there you're obliged to take design protection. So if you've made a particular garment less than 50 times, or if it's couture, for example, there's just one copy made or whatever, right? If you have made an article once, twice, up to 49 times, and you don't have design protection for it, you don't have a registration for its design, it's not as if all is lost. You will still be able to claim copyright in that article up to its 49th copy. The moment you make 50 copies of that article, 50 copies of that product, and put it out into the market, your copyright gets extinguished. In other words, if someone copies it, you're not able to then turn around and stop them from copying it because you've made it more than 50 times. So cases involving commercial products, like we have judgments involving suitcases, we have judgments involving upholstery fabrics. Someone else copies the exact same fabric, and there is no design registration in favor of, say, a Jagdish store or whatever. Then they're not able to enforce it because it's been reproduced more than 50 times. What you can do, however, is there is still a way. And that is, like I said, the 2D versus 3D distinction. Produce your underlying drawing and say, look, this is my drawing. This is my 2D drawing. This 2D drawing forms the basis of the block. that has been used on the garment. Or this 2D drawing forms the basis of the weave that is present on the garment. So you seek to enforce your 2D drawing. As a creator, as an artist, you will always have protection for your 2D drawing. So the 3D product, you can claim rights over only up to 50 copies, but the 2D drawing you will own forever. Is that clear? Right? Now, taking 2 steps back, it's a bit problematic to have questions popping up in between, but I'm trying to answer them as I go along,
So,
insofar as they relate to what I've said.
yeah. So, Shweta, Shri, you could also just ignore the questions for the time being and just focus on kind of saying what you have, and
Sure,
we can come to clarifications.
The only part I will answer right now is to say that, look, there are many, many different forms of IP protection. Right now, I'm dealing only with copyrights and designs. Terms are not interchangeable. So a lot of times people get confused and say, so like somebody asked, is a design the same as a patent? Of course not. They're 2 different terms. That's why they are 2 different terms, right? So, you get a patent protection for something that is an invention, which is functional or utilitarian, and that's not the subject matter of what we're talking about today. So inventions is not what we're talking about. We're talking about copyrighted creation. So going forward, starting today, the terms you need to remember are designs and copyrights, and not confuse them with patents and trademarks. Very quickly, what is a trademark? Trademark is the brand. Trademark is your logo. Trademark is the name in which you do business. Trademark, for example, Creative Dignity is a trademark. The Creative Dignity logo is a trademark. A trademark could be something like the Nike swoosh. Trademark could be a sound mark. So all of those are trademarks, and that has nothing to do with your artistic product. So when I say artistic products and I say something that is original, what are we talking about in terms of the scope of protection for artistic works? The scope relates to paintings, sculptures, drawings, engravings, and or what the law says, and or any other work of artistic craftsmanship. So as long as it satisfies the test of artistic craftsmanship, which you will have to demonstrate. You have to demonstrate. So again, please understand there is no one size fits all formula, right? Obviously, the law can't have a formula, because if you're saying your work is artistic, you have to demonstrate that it is artistic. So on a case by case basis, we will demonstrate how something is artistic and what kind of artistic craftsmanship went into it. Now, copyrights, contrary to what the name suggests, is actually a right not to copy. It's sort of like a negative, if you think about it that way, it's a right not to copy. There are economic rights and there are moral rights that are inherent in copyright. This is interesting. It's important for you to understand it, because a lot of times we have situations where someone develops something for someone else. There was a collaboration and there weren't proper terms that were signed in relation to that collaboration, and they find that their name has been completely dropped from that collection, right? So what ends up happening is that they think they can't take any action because the finished product was supposed to have been made by XYZ, but it has their painting or their artwork in it. The economic rights under copyright, of course, enable you to reproduce a work, to make copies of the work. So whoever owns the copyright has the right to do all of that, to issue copies, to sell, to distribute, to display to the public, to assign it, to license it. Those are all the economic rights that accrue to you by virtue of copyright. As far as moral rights are concerned, moral rights are essentially, there are 2 rights that are inherent in moral rights: right of paternity and right of integrity. What does that mean? That means that you have a right to object if your name is not used in relation to something you created. So paternity, yeah, well, we know how the laws work. Essentially means that it's your right to be identified as the creator of the work. So if you are a painter, it's another thing altogether if the work is not really identifying a specific creator. So for example, like I said, you can't say you've designed some motifs for a large sari brand, right? You can't go to the sari brand and then say, oh, but each sari that contains my motifs, you have to have a tag with my name next to it. If you haven't negotiated that, you can't get that. That's not something what I'm saying. What I'm talking about is, suppose it's a painting in an exhibition, right? Or a product that has been created. Say, for example, you've got like a Sutra Santati exhibition or something, and say, two or three artists have together collaborated and created a particular work. And the final work that has been submitted to the exhibition has been submitted by artist A. Artists X, Y, Z, who have also collaborated on the work, have the right to be identified as co-creators of the work. That is the right of paternity. Nobody, just because A put the whole thing together, A does not have the right to say that's my work alone, right? So right of paternity means you should always get acknowledged as the creator of the work. And right of integrity means you have the right to object to mutilation or distortion of the work. I had this very interesting case involving a photographer. Someone took her photographs for a book. And then when she got, proofs of the book, she realized that she had photographed some dancers and all their feet had been cut off for some reason. So she said, I'm sorry, what sort of a mutilation of my work is that? What does it mean if your dancer doesn't have feet, right? So that's exactly what I mean. That if, say, somebody comes in with a slightly warped sense of morality and decides to paint saris on all of MF Hussein's nudes, saying, hey, I own the work because I bought it from Hussein and it's lying, it's sort of hung in my drawing room. No, you can't do that. Even though Hussein may have sold the work to you, and even though the copyright in the work may have transferred to you, although it doesn't, uh, Hussein will still retain, or his estate will still retain the right of integrity to the extent of saying you can't mutilate or distort the work. So it's a right against that, which also vests in the person who's the creator of the work. So, like I said, it's something that exists for about 60 years. I notice Swati is not here, but it's a question she asked earlier to say, what is originality? Originality essentially is that it has to be a product of your independent creation. That is the test under copyright law. As long as you have independently created something, it is considered for the purposes of the law to be an original work, right? And like I said, I've told you the overlap between copyrights and designs. So now coming to a design registration. Like I said, design registration, you have to register a work in order to be able to claim rights over it. What happens when you register a design? When you register a design, you have the right to prevent others from producing, importing, selling, distributing products that either are identical or similar. What is interesting about the Designs Act is Designs Act has this classification, right? So depending on what kind of product you are seeking to register, it would fall under different classes. So like, for example, textile products would be a different class, right? Garments would be a different class. Electrical lights and fixtures would be a different class. So different products fall under different classes. We had this very interesting case recently involving a crockery designer. So obviously she has dinner sets, right? So she's got cups and saucers and plates and, side plates and quarter plates and spoons and all of those things in one range. But it is going to be quite expensive if you try to register every single piece of crockery from an entire dinner set. So what did we do? We took the plates and we registered the designs as far as the plates were concerned. So for every range that she designed of a dinner set, we registered the designs of the plates. This is where the law gets interesting, because in other contexts, you can only claim that someone's copied it, assuming, the reproduction is kind of in a similar vein, right? But under the Designs Act, you have a unique quirk in which any other article that falls in the same class, if the design is reproduced on any other article, also it amounts to infringement. So that's pretty helpful because the person who copied her had used it on coffee mugs, but her registration was for plates. So despite it having been used on coffee mugs, we were able to get an injunction against this third party. So that's a very interesting quirk in the design law. It's very important to know. However, the design law has a bit of a flip side, which becomes critical for you all as designers. And that is, and this is the same thing that we have also in our patent law. You can only secure design protection till such time that your product has not been launched. In other words, if your product is in the market, or if your product is on social media, or if your product is on your website, or if there's a fashion show you've done with the product, or pictures have been taken of it and it's out in the public domain, you cannot get a design registration. So you can get a design registration only for those products that are still at the stage of pre-launch. You cannot get a design registration for products that have already been launched. And that is why what happens for a lot of people who've not secured design registration for their products is that we can only rely on copyright for those people. Because if so, I mean, I'm not saying that you can't do anything. I'm just saying that, for those products, then you can only rely on copyright law to the best that we can, uh, for the simple reason that the designs are already in what we call the public domain. So it's very important for you to remember, if and I understand that as a designer, in the early days, you don't have the bandwidth. You're too busy designing your products. You don't have the bandwidth to go seek registrations, and that's a fair enough point. But I think in the course, in the lifespan of what you start doing in in the lifespan of your product life cycle, if you see that your product, for example, is something that is getting copied very frequently, then what you need to do is, for your future products at least, before you put them out in the public domain, please apply for design registration. You don't have to wait to get the certificate in hand. If you apply for it yesterday, so for a lot of fashion designers, for example, who we work with, it's very simple. If the collection is going to go, uh, if the collection is going to go into, say, a fashion show, like a Lakme Fashion Week or whatever, FDCI, if it's going to go on the ramp tomorrow, then even until today, we're good. So, your garments are ready or whatever, you take. So, what I will advise you to do always is ensure that you have a checklist ready. So, you're not reinventing the wheel one day prior to launch. You know already what is it that you need to do. So, for example, there are certain, the garment, for example, or whatever article you seek to register, has to be photographed from a minimum of 4 angles. You know, what we in law call the top view, the bottom view, the side view, the perspective view, right? So, if it's a flat lay, for example, like a sari, then also we will give you illustrations in terms of how you can take 4 views of the sari. So that is critically important when you want to. So then, the views have to be against a plain background. It can't be draped on a mannequin, or it can't have any noise in the background. So all of those things are very important, because sometimes, because of the quality of the photographs itself, it gets rejected. So it's very important that you do that preparatory work, uh, and you know what documents are required, you know what is to be done. So you keep that checklist handy. And up until, I mean, it's fair enough that you may be tweaking it or making modifications right until the last minute. Only when it's final, you can then apply for design registration, but make sure you do it before launch. Costs obviously is not something I'm going to go into in the course of this conversation, because that will differ from lawyer to lawyer. And those are conversations you'll have to have independently with lawyers. But as far as government fees are concerned, I think for individuals, it's 4,000, and for companies, it's 9,000. That's the government fee. And then on top of that, the lawyer's fees. Um, as far as the process is concerned, um, trust me, I will cover all of this. Just bear with me. So, as far as the process is concerned, whether it's copyright or designs, like I said, copyright, it's not mandatory to register, but a lot of people. So, for example, if you look at films, most of the production houses, the Hollywood producers, the Bollywood producers, all prefer to register copyright for their films, because, films have so many people working on them, and the law recognizes the producer is the owner of the film, and you don't want any controversy or dispute later. So, they do register copyright in films. So, whether it's films or books or whatever, typically people do apply for copyright registration. So there the process is the most streamlined, because there isn't a lot of scrutiny, and it takes anything between 3 to 9 months. So, I mean, 6 months being an average to get a registration. As far as designs are concerned, if there are no objections, so like I said, if there are no objections to the quality of the photographs, or sometimes they want you to disclaim certain things, I'll explain disclaimers. Mm. If there is no objection from the designs office, then it is something where you should expect a design registration within about 6 months. If, however, uh, it is something where, so like I said, your launch is not dependent on that. So even if you apply yesterday, you can go ahead and launch today. You don't have to wait for the registration certificate in hand. And then that's good to go. Like, you have to renew it once, but it's good to go for 15 years. After that, it goes into the public domain. But what ends up happening is that, moving on to disclaimers, one of the objections that the designs office often raises is that, look, you've tried to get a registration for a handbag, suppose. And what is unique about that handbag is obviously the pattern on it. But you've got a very basic leather handle. So they will say, look, disclaim the handle, or disclaim the buckle, or disclaim, the zipper, or disclaim the name of the brand on it, because the brand name is a trademark. It doesn't come under design protection. So that is what we talk about as disclaimers, right? So if your lawyer hasn't identified appropriate disclaimers, or is it, designs office wants more disclaimers than what have been identified, then those are the kind of instances. Or sometimes they want different photographs and things like that. Or sometimes they are getting very clever these days. And so they are using Instagram and things like that and saying, hey, we found a similar product. And then you have to sort of clear your throat and say, sorry, buddy, that is not similar by a long shot, and you don't really understand it. But, those are things that we need to do a little bit. And so if those objections come, then I would say outer limit is 1 year. But 6 months is a good, sort of ballpark to expect to get registrations. As far as your no, you can't get copyrights in titles. Like I said, title is not. Remember what I said at the beginning? Let's go back to that. Works of authorship or artistic works. A title is not a work of authorship. A title is something that you can get a trademark for. It's like a slogan or a word or a brand, right? So it's similar to that. It's too short to be protected under copyright law. Copyright law, works of authorship would need in the least for it to be a limerick, you know, like what you're essentially saying is it's not one word, or it's not, a sentence, or not a phrase, right? So no, designer isn't generic terminology. I haven't used the term designer in relation to the law at all, in relation to the question that has come in here. I've repeatedly said artist, and artist is not generic terminology. So whether you call yourself a designer or you don't call yourself a designer is irrelevant to the conversation. What is important is, have you created a work of artistic craftsmanship? Have you created an artistic work? Are you the artist or the creator of a work? So the only word that the law is concerned with is creation. If you are a creator, you are entitled to get protection, whatever you may call yourself. And yes, it is possible for the law doesn't distinguish between Indians or foreigners. Anybody can get a design registration or a copyright registration. As far as IP is concerned, everyone is treated equally in the eyes of the law. You cannot, as I have identified for you specifically what you can seek protection for. So no, aesthetics and styles are not protectable, because an aesthetic or style is not. Remember the test that I said? Can it be protected under design law? Is it capable of industrial application? Can you reproduce a style? You can't, right? Tangibility is the most important part of getting protection, either under copyright law or under design law. If something is in my head, it's not protectable. If it's an idea, it's not protectable. So many people come and tell me, oh, I have this great idea. How do I protect it? You can't protect an idea because that idea is sitting in your head. How does that idea translate onto paper? So sometimes I say, take that idea, make a concept note out of it. Then that concept note can get protected as a work of authorship, right? Then it's a literary work. Uh, but there are limitations to that protection, because if you protected it as a literary work, as a concept note, then the execution of that in the real world is not something you're going to be able to enforce, right? You can't say today. So, for example, we had this very interesting case some years back, where I don't know if you remember. This is back in the crazy 90s. There was this television show called Swayamvar, and so there was this on ZTV, which used to be hosted by Madhuri Dixit. I know a lot of these things because of them ending up in the courtroom, in my defense. So there used to be this show called Swayamvar, and somebody sued, ZTV, saying, hey, I pitched a similar idea to them some time back, and they essentially said it wasn't viable, commercially viable, and then they gone and launched a similar show. So what was very interesting was that he didn't only pitch it orally. What he did was he sent them an email. And this is something I advise all my artist friends and author friends, that when you're pitching to somebody, capture it in an email. If you're doing a presentation, attach that presentation in an email and have a little copyright disclaimer at the bottom of that email, where you say that the text and the images in this email are proprietary to so and so and may not be reproduced without the permission of the author or artist. Just put a simple line like that in your email. Because the practical aspect is if you're pitching to somebody, um, 9 out of 10, the bargaining position is such that you can't really go in before a pitch and say, hey, I want you to sign a document, which will say you will keep stuff confidential. No one's going to sign it. They'll say, go. So, how do you still protect yourself? You protect yourself by memorializing the fact that you actually pitched this to them. You protect yourself by sending a follow up email saying, hey, this refers to our meeting today where I showed you the following 10 designs. You have said you will get back to me whether those designs can be applied or not. Then, if they apply those designs and cut you out of the picture, you've got evidence that you pitched it to them. So, always keep a paper trail. That is an incredibly important piece of advice that your lawyer should be telling you, your lawyer is telling you. Keep a paper trail. Add that little line everywhere saying, these images or these cannot be reproduced without my permission. We are going to have conversations with artisans. So that conversation is going to be a separate conversation. And it was, in fact, something that I wanted Creative Dignity to do, to split up the audience between designers and artisans, because the conversation is very different. So I'm not covering artisan related conversations here. However, what I do want to tell you is that for many of you, you are the creator, the conceptualizer, the designer, the artist behind the work, but you're not actually the person who ends up executing. You're not the person, many of you here in this room are not the people who actually weave the sari or make the product. So it's very, very important that you have proper contracts in place with the folks who do that for you, especially if they're not your employees, if they are job workers and third parties who you engage. That is something that you need to have in place. So, okay, my tea is now water. What you need to do essentially is that now, again, here also, I hear a lot of people say that the practical problem is that folks say, I don't understand it. I mean, we've done translated Hindi and vernacular agreements for clients so that they can get them signed by their job workers, depending on where the job worker is located, just so that, we don't end up in a situation where the job worker believes that those designs, because they're executing them on the garment, those designs belong to them. And there is a little bit of that, a legal paper is a great deterrence. Let's face it. The practical aspect of telling somebody, hey, don't copy it. Don't go and make, 20 copies and sell it in the open market to the highest bidder, because I've got this paper, which you've signed, saying you're going to be liable in law if you copy my designs. Consequently, what ends up happening is that a lot of job workers say, this is a legal document. This is not something that I am willing to sign. So what do you do in an instance like that? Paper trail again. What is your paper trail? I have had conversations with designers who, for example, give AutoCAD drawings to people who execute them on garments for them. So obviously, if you're giving an AutoCAD drawing, you're giving it typically on a pen drive or, in the early days, a CD or whatever. What I will recommend is make a Google Drive link and drop it by email, or send them a follow-up email saying, oh, just for the purposes of the record, noting that I had given you AutoCAD drawing under serial number so and so, so and so, and so and so today. Drop an email to them. Or send a WhatsApp. See, you have to understand that contrary to what people believe, the two biggest myths about law is that anything legal has to be in legalese. In other words, it has to be incomprehensible English that neither you nor I nor anyone else understands. Not true. Me writing back to Creative Dignity saying, hey, I agree to do this event is also a contract, right? So contract need not be on a type of paper. It need not be on stamp paper. It doesn't have to be notarized. It doesn't need witnesses. As long as it's, like I use the term memorialized, right? As long as it's memorialized somewhere in some form. It could be WhatsApp. The fun fact, in the Delhi High Court, unlike other courts in the country, in other parts of the world, our Indian courts are so modern we are allowed to serve papers to, the opposite party in a case through WhatsApp. So sometimes you don't have contact details of somebody. You don't have their address. You have someone who's copied a particular pattern and they put it on a website. Say, someone who's selling products off a website, and you realize, oh, you can place orders online and there's an email address to communicate, but there's no physical address. You don't know where their store is, you don't know where their warehouse is, you don't know where they're located, which city, nothing. And they have a phone number and they have an email address for returns and exchanges and that purpose. So what can you do? The court allows you to serve court papers through email. The court allows you to serve court papers through WhatsApp. So, moral of the story, any form of communication, as long as you're memorializing your interaction, any form of communication will work in law. Keep that paper trail. Keep documentation. Every time you create a work, if you're creating it on the computer, if you're doing it with pen and ink, scan it, save it in a folder, and name that folder, give that folder a name on the basis of the date of creation. Because 10 years later, if you're going to enforce that work against a third party, it's very hard for you to remember what the exact date was when you created it. But as your lawyer, if I have to go to court and tell the court that my client created this work, I need to be able to tell the court the exact date on which my client created this work. So save a folder where the name of the folder is the date of creation. In that folder, put everything concerning that work, whether it's a scan of your sketch, whether it's a scan of the painting, whether it's an AutoCAD drawing, whether it's 2 or 3 iterations. Do not overwrite those files. Version 1, version 2, version 3, final version. Why? Because tomorrow when someone challenges and says, prove that you created it, you're going to be able to show that you made all these modifications to it and came up to this final iteration. So it's great to save different versions, mock-ups, absolutely. All the different things that help tell the story that you created this sitting somewhere. I remember a designer once wanting to enforce rights against somebody who they said had copied their work. And I said, okay, give me proof of your creation and we can have a conversation. And what they gave me, I kid you not, was a sheet of paper where they had written, they made a rectangle and they'd split the rectangle into what you can tell were meant to be the borders of a sari and the pallu. So the rectangle had like a ruler, they'd taken a ruler and they'd essentially drawn a line on top, a line at the bottom, and a line at the side for the pallu. And at the bottom, they wrote coin booters. The top, they wrote coin booters. And on the pallu, they wrote mile, that is the peacock, and then coin booters, and then peacock, and then coin booters. And then they wrote red for the sari and green for the borders. And they said, my copyright. I said, absolutely not. You haven't created anything. You've essentially given a set of instructions to somebody to reproduce a pre-existing traditional motif in a particular layout. That does not satisfy the work, the test of artistic craftsmanship. So the qualitative assessment of whether you truly deserve to be called a creator or not, that qualitative assessment can be best done when you've got your paperwork in place, which shows that you actually created it. You drew it or you did it on the computer or whatever. So that's very, very important in order to be able to enforce it. Now, once you've done that exercise, so we've talked all this while about protection. I know I've talked a little bit about enforcement, but we've talked about protection largely. I have asked Creative Dignity, and this is in response to something someone said a short while ago. I have asked Creative Dignity to perhaps schedule a separate session on geographical indications, which is important because it's a subject unto itself, which is quite extensive. So we are not covering GIs today, but GIs relate to traditional knowledge of a community or a traditional practice. Today, I'm restricting the conversation entirely to things that are created by creators. So something that originates with you and is not the cumulative knowledge of the community. We are looking at that. So the GI and the GI protection is something which we will have to park for another day. So today we're only talking about what you do. So now, when it comes to enforcement, how do you enforce? The law is very clear. No one can copy something that belongs to you. If they've copied it, a good starting point could be sending somebody a legal notice pointing out your rights, a lot of times what ends up happening is that, you don't take action. And you're cribbing about the fact that people are copying and stuff like that. But if you're not going to put it out there, look, at the end of the day, it's about deterrence, right? I mean, to use parenting examples, if you have a kid at home who's constantly playing truant and you're never going to tell the kid to stop doing what they're doing, they will continue to push the envelope, right? So somewhere you have to let them know that you are aware that they've copied from you, A, and B, that you are somebody who is willing to go that extra mile to take them to court or whatever. A lot of times we see that a legal notice is sufficient for people to back off. Most of the time, you have resellers and things who will try to blame the job worker, and they will say that, this is the person who has copied it, and they just gave me the product and I didn't know, and stuff like that. The answer is simple. The law actually does not distinguish between who is creating and who's selling, because both, like I said, remember the economic rights that I talked about? All those economic rights, copyright is called a bundle of rights. All those economic rights flow from copyright. So it's not true that the person who created the infringing work, or the person who manufactured the product, or the person who sold the product have different or varying levels of responsibility. The law treats them all equally. If you are the front facing, the customer facing end of the entire food chain, right? In other words, if you're the person who's selling the infringing product, you are liable. It doesn't matter whether some craftsman gave you that product, or you didn't make it, or you didn't design it, whatever, it doesn't matter. So to answer your question, Swati, if somebody has copied your work and is selling a finished product in the market that is identical to or resembles your work, you certainly have the right to take action against them. What you choose to do against them will depend on, how far you're willing to go. You can start with a legal notice. If they don't comply, if they don't respond to the legal notice, you can file a lawsuit for damages. I remember some years back, we filed a lawsuit for Nida Mahmood, when there were, and it's reported, so there's no difficulty in talking about it, where there was a particular garment of hers that found its way into Shopper Stop shelves, and they were all over in the Shopper Stop shelves, right? And so we sued Shopper Stop, and they settled. So a lot of times people think about the fact that, oh, this is such a hassle. But if it's a well-known brand the other side, you could end up covering your litigation costs and getting a little bit over and above that as damages. And in some instances, if it's a really small entity, you can simply, do it by way of, setting an example. Whatever the motivation, the point is you can stop those products from going out into the market. In fact, what is interesting is in law, we have a provision called appointment of a local commissioner. If you get a local commissioner appointed by the court, right? If for example, it's a large brand and it's got like, the warehouse location, or where you're going to get a large stock of infringing products, then what you can do is ask the court to appoint a local commissioner who can actually go to the premises of the, whatever, plagiarizer, copier, and take custody of the entire stock of infringing products, seal them, and they can essentially put them in under it's called Supadari, right? Supadari is essentially where, sort of, obviously it's not possible to bring physical products to the court. Where is the court going to store them? So they are kept with the counterparty, but they're sealed. And if they are really large quantities, it could even be an entire room that is locked up. And, proper seals are put on all the boxes or bags or whatever. And they have to sign and undertake that they are not going to sell the products. And that at any point in time when the court demands, they will bring the products and they will bring the inventory. So the whole thing is inventorized and they're not able to sell the products. And then at the end of the case, we use the quantity of products and the value in the market to determine what damages are payable to you. So it's very useful to be able to do an exercise like that. Now, urban legend, myth. I've heard 7, Swati tells me 5, urban legend. This little story that seems to float around in the designer circuit. I want to know who the author of this story is. I have to give them credit. because they've made the most amazing urban legend I've ever heard as a copyright lawyer. And that is, if you make 5 changes or 7 changes to a product, then it's no longer copyright infringing. Yeah, that's completely made up. Doesn't exist. What does the law say? What the law says is, and this is to protect creators. The law is designed uh, in a way that people don't make changes and get away. So the test in law is, that's why I said, there can't be a formula. The law is not stupid, and lawyers and judges are certainly not stupid to say that, look, this is a formula that must apply to all products, no matter what. Obviously not. Because if you're looking at the creative industry, ultimately the test that any human being is applying is to say, when I look at these two products, does it look like a copy? So, for example, the example that you showed, Swati, in the image that you showed in the chat box, I mean, to any sensible person, it'll look like a copy. So it's a straightforward eye impression that someone is using, right? So the test in law is X a copy of Y or not? The test that a judge has to apply is, has it been substantially copied? So the test is of substantial similarity. So in other words, if someone makes enough changes in it, makes certain changes in it, but it still remains substantially similar, the court will still hold that it's an infringement. So that is actually helpful from the point of view of creators and artists to say that it doesn't have to be identical. It is important for it to be substantially similar. So I'll show you a couple of examples. I'll show you some images so you get the idea. So there's this one very interesting case involving laces. Actually, I'll show you one of my first cases at the start of my career as an IP lawyer. This is what I've been doing for 22 years now. So this was a fun one because when I started work, then some of the first cases that we did involved Ritu Kumar, and Ritu was essentially suing a bunch of these people in Calcutta who had essentially gone on to copy all her works. Now, if you see this, let me find a way to show you justice. What am I doing? Here. Can you see just this slide on my screen? Yeah. Okay. So if you see this, these were some of the cases that we filed on behalf of Ritu Kumar. I'm comparing for you the original and the copy. Can you see they're actually quite different if you apply your 5 changes or 7 changes test? But in reality, the creator knows that they are similar. So if you see the original, this has kind of gotten moved, but this is the original. Oops, sorry. What have I done? Yeah, I will do this again. This is what happens when we no longer do Zoom. Here you are. Here. So this is another example. For some reason, it's moved on to the other one. This is involving lace. Now, please look very carefully at it. And you can see that there is a certain amount of copying, but there's also a certain amount of differences that the copier has introduced. Even then, because if you see the trellis pattern, the court said, if you look at the trellis pattern, yeah, sure, that central flower has been changed, but there is enough similarity for the court to hold that infringement had occurred. So if you look at this, you realize that there is a fairly, largish room to argue that copying has taken place. The same was true of Ritu's designs. Let me try and bring that slide back. Yeah. So if you see this, both the umbis as also these chota flowers. Now, of course, these chota flowers have become very common. You see them everywhere. But if you see, these had been copied and the court held that they were copies. So it's very interesting to see that despite the change in the color combination, despite the fact that Ritu's umbis were a little bit rounder, the ones that were copied were a little bit narrower, despite the fact that there were other elements that had been introduced in between, the court still came to a conclusion of copying. So it's important to understand that as long as the overall look and feel is the same, courts will actually come to your aid. Um, Somebody wanted your image to be shared on the screen. Happy to do that. Swati, I'm just sharing this for everyone's benefit. This is what Swati shared with us at the start of the presentation. It's hers, and this is the copy. So as everyone can see, this is clearly a copy. And on the substantial similarity test, it would certainly qualify. So that's kind of by way of an example. And when you come to products like this, Swati, what you were showing, what ends up happening with products like this is that because the product itself is so different and unique, that it's hard for someone to say, hey, I came up with the exact same thing at the exact same time. A lot of times people try to take that defense. So yeah, Meeta, over to you. Do you want to moderate and maybe open up for some more questions? This is kind of the background I wanted to give all of you, but I'm happy to hear more questions.
So I think I'm just going to come in while Meeta looks at the questions and what is left to be answered to kind of just sum up. So we've
Sure.
seen uh, two main ways that designs can be kind of safeguarded, one with copyright and one with design registration. And we've seen the difference. Sorry, also children in the house. Sorry. So just kind of wrapping up in terms of how we go about our work as designers and as people who continue to work with craftspeople, but to safeguard what we're doing, because we will, and this is for everybody, we will have a session tomorrow again with Shwetasree around what artisans can do to safeguard what they have. But today's session was specifically for designers and entrepreneurs to look at what is the IP that they're creating and how they need to safeguard it. So we've looked at one, before you make anything, whatever you do, save it, date it, keep a paper trail of everything when you exchange it to in anybody, and before it goes into public domain, do send it for design registration if that is one of the way you want to safeguard it, if that is a clear application. But even for things that you have created, if it, for example, somebody who, like you said, may have a design registration on a plate, but if it finds on a mug, there is still a way to kind of use that design registration to safeguard it and enforce that. But my little question is, suppose that drawing ends up on a bed sheet, you can still use copyright as long as you can show that you had the drawing and you were the one who came up with the drawing, right? So there are ways to do this, and they will change a little bit. But this 49 products, if I have made 50 products of that, then am I not allowed to, like, if I made 50 cups, would that mean that somebody can still use it on their bed sheet? So could you just clarify that?
Sure. So if you are essentially enforcing it as product versus product, if you're enforcing cup versus cup and you don't have a design registration, if you have a design registration, you can make as many as you want. It doesn't matter. Your right will be secured by statute, by the law. If you are trying to enforce an unregistered right? The unregistered right, you will get only up to the 49th copy. But like I said, up to you making 49 copies, not the copier. But like I said, trust the creativity of your lawyers. If you have a problem, go and articulate it. Don't try to resolve it in your own head. Go and articulate it to your lawyers. So, like I said, there also we have solutions, because a lot of times what ends up happening. So, for example, some of the lawsuits we filed for Tarun Tahiliani, you know, the pattern may be on a sari, and the person who's copied it has done it on a kurta. So anyway, we are enforcing the underlying pattern. We're not enforcing garment versus garment. So all we have to do is not, because it is only the garment that is registrable as a design. So we are not enforcing it as a design. We're enforcing the underlying artistic work. So if it's the underlying artistic work, you can always enforce it even if you made more than 50, which of course in Pret you don't.
Great. So, Meeta, I think it'll be nice also for maybe Meeta to come in now and also talk about, some of the challenges that she's faced, because I think it helps to have like concrete examples of, what was created, how it was infringed, and what has happened with her, and then maybe go on to specific instances that other people have shared.
So, Shwetasree, you've been most efficient, of course. You seem to have covered all the questions. I can only find one that's still pending, and that is by Swati, who asked if she has a 10 designs per garment and she wants to make sure that they are not copied by anybody. What do you suggest? Like when somebody puts out a range of whatever, kurtas, saris, whatever, with specific designs. So what do you suggest they do to protect to make sure that they are not copied?
So, like I said, it'll depend on whether it's already released. If it's released, you can't get design protection anyway. If they're not released, then you'll have to have a conversation because these things are all on a case-to-case basis. You'll have to
Yes.
have a conversation with your lawyer, take the portfolio to the lawyer, have a conversation with them in terms of what protection can be obtained, and they will guide you best to tell you, how you can get protection.
Right. And in case people are not doing that, then like you said, just make a trail, make sure that you document through the creative process at every stage, at every iteration. If you can make a paper trail of it, then that makes sense. And the line that you suggested writing at the end of every email or anywhere where you exchange images, silhouettes, anything that
Yeah,
also helps in some ways. Maybe scaring people off more or
sure.
less, depending on the person, on the group you're dealing with.
Because you have to understand that when we're looking at things from the perspective of a lawyer, we are not fettered by copyright alone. There are
Mm.
laws of breach of confidentiality. There are laws of unfair competition, trade secrets. There are so many things. So for example, if you look at the software space, so many times it happens that a software engineer leaves a company and they take the source code and they go and make the same app or they make something elsewhere, right? Now
Mm.
technically the source code of an app is protectable as a literary work under copyright law, right? However, sometimes this breach of confidentiality or theft of trade secrets and things like that, those laws also come into play. So that's why I said it's very important to get legal advice to understand. Go with your fact situation, go to a lawyer and say, this is the problem I have. Do I have a resolution? How can I resolve this? Very important, because a lawyer may think up creative things which I haven't, it's not possible in a generic way to envisage every
Yeah.
scenario and give you examples. So there may be other ways of seeking redressal, even though you don't have design protection, or what you have is an idea and is not something that is even copyrightable. You may get protection under trade secret law. You may get protection under, like the Coca-Cola formula or whatever, right? So there are so many different ways in which you can get protection.
Yes. And like Anchal suggested, I came to you as a client because I had a print of mine which has been made over 25 years back, and that was being copied left, right, and center. And a particular company was using that print on their shirts. And over to you, Shwetasree, maybe you can tell us how you did that magic and got me the post. Of course, it was not copyrighted. It was not, legally protected in any way. But what was it that you guys did?
Yeah. So like I said, Nita didn't have a design registration. So we used the underlying copyright. We were able to show that she had created it. We were able to, through documentation, and Mita is well documented in the public domain. So there was enough material to show that had been part of her collection. It had been, widely publicized and as belonging to Mita. And so it was easy to prove that she was the owner of copyright and she was the creator of the work. And therefore we were able to sue and get an injunction against the person who was essentially selling shirts with that same print. And and obviously they took down the product after that. And essentially this is the point, right? That you send out a signal to the market, you do a little bit of press and publicity around it. Mita's loath to do that, but some of you may see the benefit of it. Then what that ends up
I'll get
doing is
there.
what that ends up doing is, a lot of times we've seen that the first time you take action, people suddenly say, oh, this one's taking action as well, maybe a good idea to shift my attention to someone else. So it's important that you send out that signal in the market. I think we have a new question. Do you want me to take the next question, which Amitra has asked?
Yes. Should I I'm sure you can
No,
read.
yeah.
Yeah.
Okay. So when we're talking about, like I said at the beginning, it really again, this is something that I can't answer in absolutes simply because it will be in relation to a particular. So a design registration or a copyright registration is never for an AMBI per se. This is what I said to you earlier. No one
Mhm.
is registering a lotus, so no one is registering the AMBI. What you're registering is a garment where the AMBI is interpreted in a particular way. It is laid out in a particular format. It will, so, we often simplify it when we say, hey, someone's gone and registered an AMBI, but that's not true. It's not an entire sari or a garment with one AMBI in the middle, right? It'll be a particular layout, there will be a border, there will be something intervening, right? So it may be a traditional motif, or many of us work with traditional motifs, right? Many of you work with traditional motifs. But that traditional motif is then, if you look at the Ambi alone, there are so many different interpretations of it, so many ways to make it. So the protection is for that artistic interpretation, that artistic vision concerning the Ambi, the way it appears on a garment. Like I said, it's the aggregate. When you're protecting a garment, it's an aggregate of all the other motifs that come on it, how the layout looks, what the color combination is, unless the colors are disclaimed, in which case the protection is only for the layout and the pattern, the borders, all of that comes together.
It's like the Ritu Kumar thing that you showed us.
Yes,
It was
exactly.
the layout, the
It
exact
was
layout.
the,
And the
yeah,
Ambi was typical and the flower was typical, but the way it
and
looked.
all of it had like little additional minutiae within the Ambi, and there
Mm.
were like stuff surrounding it, and all of that had been taken.
Yeah, and also with time, I think some of these that we think are like traditional have also been done by somebody, but have become so widespread that we start to think of them as traditional. So I think tomorrow also the session will be probably be quite interesting to see what these boundaries between what design does and what the craftspeople do, and what are the agreements between them that need clarity. Like we've today talked about, how do you have contracts with your employers, with people who are going to sell your stuff, who's going to make your stuff, and to have all of this clarity. I think tomorrow this relationship between craftspeople and who they work with will be a lot clearer. So I'm going to request Bhakti also to share the link to the session tomorrow, so that people can spread the word, so that anybody else, from an artisan perspective or a designer perspective, everybody is also open to kind of joining us tomorrow. The session is tomorrow at 5 p.m.
Do we have any more questions today? Does anybody have any more questions?
I can see Shankar asking, who is the authority to grant registration, patents and trademark office in Chennai or any other?
It is so the Patent and Trademark Office has geographical, sort of branches for administrative convenience. The IP office, it's not just the Patents and Trademarks Office, it's the IP office, which also covers copyrights and designs. The IP office is central in the sense that it's electronic, so you don't have to go to the Chennai office, or you can't, in fact, physically go to file anything. The registrations are granted by the Intellectual Property Office, yes.
And I see a question from Mugdha to Creative Dignity. So maybe Bhakti, you can take that. Will CD be sharing a recording of this anywhere?
So I can answer that. We are recording this to be shared, but also that we would like, therefore, with all this information that Shwetasree so generously shared, for us to come up with like a small document, so that you can use it as a ready reckoner and to know what you should be done, because also it's a lot of information to process at one go. And I think it should be something that we feel should be widely shared, and let us have this transparency on what law can do and what it can't. So thank you, everybody. If there are any last questions, we can take that. Or otherwise, I think I'd really want to say thank you so much. I was so impressed by the conversation that we had in August, and the clarity that you brought to say, okay, this is not fuzzy. It is not a gray area. There are very clear cut things that the law can let you do and what it can't do. And of course, there are some areas that we would like law to do more, but that comes later. First, we must know what law does and kind of use that enough. And so thank you very much, Shwetasree, for this. Absolutely, like, I think 1 hour passed and we didn't even realize it. You were so articulate and it was so engaging to hear you speak. So, on behalf of all of us, thank you very much. For those who are new to Creative Dignity, it is a volunteer network that came together during the pandemic, and it continues to engage different stakeholders of the craft ecosystem. And one of the big things that we've always been talking about is how do we start to safeguard what we do in the ecosystem, whether it is through designs or what the crafts people do themselves. And so again, I'm giving this plug to the session tomorrow with amazing Shwetasree again, and we look forward to seeing you. Thank you so much.
So I'd like to say something. Thank you, Shwetasree. Like I second what Aanchal said. Absolutely. I have not seen people sit or everybody be engaged with such a technical conversation for so long. But I remember you had some highlights on your Instagram about IP. Is that still there on your page?
Yeah, so Instagram, unfortunately, has taken away those what were they called earlier? They used to be called something else.
Highlights,
Uh,
Thana?
Nee, they were called something else. Anyway, so I had started doing these sessions on, like 1 or 2 minute little nuggets on like copyright fun facts, design fun facts. Guides. Yes, Nikita's right. They used to be called guides. So guides have disappeared. I see them now on my Instagram, like they're sort of saved in some strange way, but I don't know if y'all can access them still. I mean, I sort of see them as saved pages, but I'm not really sure if people can see them. So you'll have to check my Instagram to know if you can still see them. But there's a lot of copyright ready reckoners and design ready reckoner. They are just showing as saved files. Today they're showing as saved, like saved posts and saved files that we have. So I don't know if they are viewable to others.
So
Not
if
sure.
you're comfortable giving your Instagram link, maybe you could
Sure,
do
it's
that.
it
Yeah.
is a private account, but it's Sari Samurai.
Okay. Thank you.
Thank you very much.